with us today again in this marathon arbitration course, week-long course. Now today we will start with Sasi Singh says good evening. Thank you, Sasi. Thank you very much. Now today we will start and cover in very brief one aspect which invariably one's come across during the course of arbitration. That is about the challenges made to Sujata Sirolkar. Thank you. Good evening. During the course of arbitration or on appointment of arbitrator, Sumit Kansal. Oh, somebody, Sumit Kansal asks a question whether arbitration proceeding is adversarial proceeding. Yes, Sumit, it is adversarial. However, with a rider that it is not completely adversarial in the classic sense of common law proceedings being adversarial because of the amalgamation of the procedures of civil law system, civil law jurisdiction, and common law jurisdictions. And now you have very aggressive case management, which is rather supposed to be done by the arbitrators. Again, case management is something which has its basis in source in civil law system. So therefore, it is not in a stricto sensu, in that classic sense, it is not an adversarial proceeding. But yes, it is predominantly it is an adversarial proceeding. That is the answer to your question, Sumit. Let me come back to the point which I was trying to cover. Joel says, how in view of Balco judgment, the Indian courts have jurisdiction. Indian courts will have jurisdiction with regard to two aspects. It seems you have not attended that class. One, so far as part 1 is concerned, in part 1, section 9, section 27 and section 37 are applicable with respect to foreign seated arbitration for the reasons I had mentioned, because of some urgent relief or some support of court you need, so you come for that, note otherwise. So part 1 doesn't apply to foreign seated arbitration. Arya says, I have defined arbitration. What I will do is, today I'll try to conclude the class today's talk 10-15 minutes before call the question. So if you can hold your questions back for a while, let me cover as much as I can in today's talk, and thereafter we will take every question. So keep noting down your questions, keep writing your questions, and then you can throw it to me, and I'll try to pick them up one by one. Okay. So Muhammad Arham says, yes, that's good. Okay. So let us then carry on with this. And so to that question of Balco, part 2 obviously will apply to Balco, because if foreign seated arbitration is brought to India for enforcement, execution, so in that case it will be applied there. Now coming to the topic of today's talk, first is that when can you challenge the appointment of an arbitrator, and what are the procedures? So you can challenge any appointment of any arbitrator if you find that arbitrator is not independent and he is biased, so you can challenge his appointment. Now, independence and impartiality, these are the two expressions which have been used. So independence is independent, arbitrator being independent means that he is independent of the parties, independent of the subject matter, independent of the outcome of the parties. And impartiality means he should not be partial, he should be impartial. So these are two expressions having different connotations. So that this is what we have to keep in mind. And in our Arbitration and Conciliation Act, you have two schedules, Schedule 5 and Schedule 7. Schedule 7 is something which talks about certain situations in which nobody can be an arbitrator, which gives rise to justifiable doubts, and that needs determination. So one is that appointment per se from very beginning is bad if a situation falls under Schedule 7. And so far as Schedule 5 is concerned, it gives justifiable right. However, appointment per se from beginning is not bad. One has to bring its position before the tribunal if it is domestic arbitration in India, and arbitrators will decide. In institutional arbitration, generally the such challenges are decided and determined by the court of that particular institution, the apex body of all these institutions, generally called court. And in ad hoc arbitration, tribunals members themselves will decide whether that particular uh, objection brought by the party is right or sustainable or not. Now, I will give you one judgment. Just read one judgment and it will clarify all the doubts you may have about Schedule 5 and Schedule 7, some overlapping circumstances mentioned in 5 and 7. What is 5? What is 7? When one can be challenged, one cannot be challenged. Some of the judgments given by Supreme Court in TRF, where it says that somebody having interest in the outcome cannot be the arbitrator or cannot appoint the arbitrator. All your queries will get addressed. So what you are supposed to do is read Section 12, read Section 13. 13 gives you procedures how you can make the challenges. 12 talks about that if somebody is not independent and impartial, then his appointment is bad and his appointment can be challenged. And the arbitrator is supposed to be independent and impartial throughout the proceeding. So note down one judgment, and that is Bharat Broadband Network Limited. Bharat Broadband Network Limited versus United Limited of Justice Nariman. So you read this judgment, it will answer most of your queries which you may have about these two sections, sections 12 and section 13. So this is one thing you should keep in mind. So far as procedure is concerned, procedure says that within 15 days of becoming aware of the issue of independence and impartiality of the arbitrator, you have to raise your objection before the tribunal. So that is one procedural requirement you must follow. Now, this requirement of 15 days is also in line with rules of LCIA, London Court of International Arbitration. They are also, you are supposed to make the challenges within 15 days, and the arbitration is supposed to be and raise your objections with regard to the independence and impartiality. So, next topic of the day, and this topic is very important, and this topic gives you basically it is in continuation of what we discussed in some detail yesterday, the appointment of arbitrator. See, during this talk on all these 7 days, what I have done is I have tried to focus on the fundamental aspects uh, which really are very relevant and important for the whole process of arbitration. And I'm trying to cover as many points as I can, those points which you don't get find any literature or commentary that easily. You don't have too much many material on that. And I'm also trying to cover my practical experiences, because difficulty with arbitration is it is confidential proceeding. So what happens inside the arbitration room within the four closed doors or walls, it doesn't come out, and therefore it is better to share those experiences and practical experiences. So that is my endeavor. Now, what is the source of power of any arbitrator? There are essentially two sources. One is the arbitration agreement, and second is treaties and conventions. If you remember, in the very first on the very first day, I had said you must have arbitration agreement in order to have arbitration. However, there is one exception to it, and that exception is treaty arbitration or convention arbitrations, where a state enters into agreement with another state in which they have arbitration provision for arbitration as well. So those bilateral investment treaty or multilateral investment treaty or various conventions like ICSID. So these are the two sources for power of any arbitrator. Now, next point is that what are the roles of arbitrator? What is the role of an arbitrator or arbitrators in a panel of three or whatever? First thing is they most important thing is, and I had said so yesterday also, most important role of an arbitrator and duty of an arbitrator is to pass an enforceable award in the in efficient manner. So that is the most important thing any arbitrator is supposed to do. Arbitrators have power to pass interim orders. They can pass orders akin to the orders which are passed by court under Section 9 of Arbitration and Conciliation Act, which we discussed in some detail day for yesterday, if I'm not wrong, when we were talking about interim measures of protection. Now, uh, therefore, question is whether arbitrators have have got power to pass such order during currency, during continuation of the arbitration proceeding. Answer is yes. Only caveat that arbitrator can pass orders only against the parties, not parties to the agreement, not against the third party. Arbitrator can also allow amendments to the pleadings which are filed before it. Arbitrator is supposed to devise the procedure which is the most apt, most suitable for the arbitration. Uh, Obviously, this power is not unlimited. This power is subject to the procedure agreed by the parties. But then sometimes question comes whether arbitrator is completely helpless when parties agree for a procedure which arbitrator does not Now, obviously, arbitrators should make all the endeavors to agree with the procedures uh, agreed by the parties lawyers. But you may have a situation where arbitrator may come across very unreasonable agreement amongst the two lawyers for whatever reason. Just to take a hypothetical situation where both sides agree with themselves, both side lawyers agree that time granted for filing statement of claim and a statement of defense should be 2 years each. Now, this is very unreasonable, a very unreasonable arrangement between the lawyers or between the parties. In that case, surely arbitrator uh, owes some duty to the process, and by virtue of being arbitrator, he can refuse to agree. So these are some gray areas where, or rather, I would say, and if he does so, no court is going to say that arbitrator was wrong in what he did. Uh, and another thing I would like to discuss a bit. See, I'll tell you the purpose of this 7 days course is that all of you should look at this course from three perspectives. One perspective as a lawyer. So as a lawyer, what you want to hear, what you see in an arbitration, how you look at the arbitration. Second perspective is of arbitrator. So anybody who is sitting as arbitrator or intends to sit as arbitrator, how he should look at the whole process of arbitration. Third is the parties' perspective, the parties who are in dispute and who goes for such a process. And fourth, court's perspective, how courts will look at what all is being done in an arbitration. So these are four perspectives. You should keep all the four perspectives in your mind, so that will become easier for all of us. So it is not that we are discussing only something which is relevant from the perspective of lawyer. Now, one thing which is very important for all of us to discuss is, invariably you come across a situation where uh, arbitrators are not very bold, in a sense that invariably and very frequently they succumb to unreasonable demands, procedural demands of one lawyer or both lawyers, because they think that if they do not accept the request or demand made, it can be challenged on the ground that proper hearing or sufficient opportunity was not granted. So, in fact, Section 18 of Arbitration and Conciliation Act, which I would say is Magna Carta of the whole Arbitration Act, which is the most important provision in the Arbitration Act. Section 18 is only one sufficient opportunity and treat the parties with equality. So now, and there is no other procedure prescribed in Arbitration and Conciliation Act. It doesn't say how whole proceeding will be conducted, but it tells you that whatever proceeding you are conducting, you should keep these two fundamental things in your mind. One, that both parties should be treated with equality, both parties should be equal before the tribunal, and two, parties should be given sufficient opportunity to present their case. Now, invariably, you do not find any issue with regard to parties being treated with equality, because whenever anything comes before the tribunal obviously takes the view of both sides. So that is not a problem. Problem generally comes from different perspective, and differently, it comes differently, and that is when unreasonable demands are made, sometimes for wrong reasons, just to delay and frustrate the proceeding, or create hinder in the whole process. Then comes the question, how bold should be an arbitrator? should you always think and have in your mind that if I do not agree with this demand, then my award will be challenged on this basis. So this is, in fact, in international arbitration world, this thought process is called due process paranoia. So due process paranoia is where you are so much obsessed with this particular aspect of not having afforded the sufficient or reasonable opportunity to the parties. Sometimes arbitrator loses the control over the proceeding, and sometimes it derails the whole process. My answer is obviously any request which is reasonable, you should agree with that. Any request, uh, if you have to give some latitude, some leeway can be given, one should give. But if it is so unreasonable that it should not be granted, in that event, you should not simply get bogged down with that particular fear, subconscious fear that my award will be challenged. So that's not a very good idea. Obviously, before allowing or disallowing any such request, you should be aware of the procedure. You should be aware of the international best practices. You should know what is the request, whether such requests are made in arbitration, whether such requests are generally allowed in arbitration globally. So you should be aware of the practices and best practices. That is why I keep repeating that all arbitrators should undergo training programs, accreditation programs, uh, attend as many conferences and seminars as they can, so that they are updated with the procedures and practices. So that is one thing. So I would say that arbitrator needs to be a bit bold and think. Now, I'll give you an example how international arbitrations are dealt by seasoned arbitrators. Some time back, I was doing one arbitration in London. It was ICC arbitration. Very seasoned chairman uh, was chairing the arbitration, and we were fixing the dates for hearing, week-long hearing in London. So he suggested dates, and dates suggested were that last week of May of that particular year. Other side agreed, and I also agreed. My diaries were at that particular point of time not full. If I was available, my diary was free. And in international arbitration, dates are free much in advance, so that you need not worry about diary invariably. So I also agreed, and I sent my consent, gave my consent through email. After 20 minutes of my email, whereby I consented for week of, it was last week or second last week, I think. Second last week. I realized that for summer vacation, in any case, I had plans to London. So I thought if I get this changed to last week or have it in first week, I'll basically club this hearing as well as my vacation. So within 20 minutes, I wrote another email requesting the arbitrator, the chairman, to have it in the either last week or first week of June, last week of May or first week of June. And I got immediate response from the chairman. An immediate response was, this tribunal does not like parties or their lawyers backing out from their consent already given. So this email was so strongly worded, and I could immediately sense the approach of the chairman. And I immediately wrote back by saying, I agree with the tribunal and I don't want any change. So I could sense that this tribunal knows its duty. Tribunal is tough. Tribunal means business, wants everything to be taken with all seriousness. So this is the approach of the tribunal. And if you start doing this from day one as a chairman or as a sole arbitrator, you will get to see that during the entire process, parties will be prompt, punctual, and they will not play with the procedural timetables, and the whole process goes smooth. However, that is not to say that if there are genuine reasons for parties to seek extension of time or postponement of date, obviously one should do it. In international arbitration, it becomes a bit tricky. First of all, there will be 5 diaries which have been blocked. Second is all parties travel from different parts of world. So all tickets are done, all hotels are booked. So in international arbitration, change of dates are slightly tricky. So tribunals are relatively stricter with their timetables and procedural timetables. uh, One thing which I would like to discuss with all of you today, and all of you who have participated in arbitration proceeding in India, you will agree with me that invariably in cases, uh, the arbitrators will read the file at the time of final hearing. When finally the hearing stage comes, when entire process has been run through, at that stage arbitrator or a tribunal will open the file, will ask the parties to arrange the files. They'll start searching for missing documents or what documents they don't have, and then they will try to read the file and try to understand the case, which is just the opposite of what is the international best practice. In international arbitration, uh, all the arbitrators will go through every piece of paper the day they receive it or within the reasonable period, so that they are aware of the party's position, party's case since beginning, and it helps them in immensely in big way in dealing with uh, lots of applications, interlocutory applications which parties file during the course of arbitration. Now I'll give you an example of an Indian case which was a very big case. Their parties had gone for a process called discovery by way of production of documents. I'll deal with this issue in a while. What is discovery? But just as an example for this, I must tell you. So discovery is the costliest process in any arbitration, where parties devote months and months in digging out documents which are sought by the other side. Let me tell you what is discovery. Discovery is a process whereby one party requests the other party to produce documents. So if claimant obviously will file all the documents which they are in power and possession of. If all the documents which they have, they will obviously file along with their statement of claims or the other pleadings, rejoinder or whatever. But you may be aware of certain documents which adjudication and determination of the case, but you do not have those documents with you, and that those documents are with the other side. What do? So even your civil procedure code in India allows a party to request other party to produce certain documents which are relevant for the case. Similarly, in however, this process of discovery by way of production of documents in India is not very popular, but in international arbitration, this is one of the most important aspects. And one should be very tactful in using this discovery by way of production of documents, whereby you request other side to produce documents. And discovery is one thing which every party in the dispute, lawyer and arbitrator should be aware of. First of all, the parties, when they are, let us talk about a construction contract, whether some power plant is being built. Now you will have lots of documents which are prepared by the contractor, lots of documents are prepared by the employer who wants that power plant to be built. Now let us talk about contractor who is erecting the power plant, installing the boiler, generator, turbine, whatever. Now their staffs at the site may be writing emails and letters to their headquarters. They may have lots of internal meetings, internal weekly meeting or monthly meetings and all of this. Now in discovery, employer's lawyer can ask the other side to produce those emails and documents and minutes of meeting as well. So they can say, send us these documents which were sent by the site people to the employer, similar documents from the employer. So this is a very, very important thing. It requires lot of effort, lots of digging out of the documents. And this whole process of discovery in international commercial arbitration is done. See, in India, what you do is, in India, there is a format in your CPC under which you issue a notice to the other side saying that these are the documents I want you to produce. These are relevant for the case. And if other side produces those documents, you can rely upon those documents. Or if other side refuses to produce document, in that event you can approach the court, and court will, after examining your request, whether your request is genuine, reasonable, documents would be relevant or not, court will pass appropriate orders. Similarly, in arbitration also, people make a request. However, there is a one change. The way those requests are met, in the form in which those requests are met, there is something called reference schedule, REDFREN, reference schedule, SCH, whatever, schedule. In fact, you will remember I had referred to a book you can read for arbitration, Redfern and Hunter. So this gentleman, Mr. Redfern, had proposed this form in which discovery requests should be made. So this is very popular. So you say that I want this document, then you have another column why you want this document, then another column other side for other side's response, and the last column is for remarks of the tribunal. So it's a columnar format in which people make the request, so that everything comes at one place and one sheet of paper spreads it, and tribunal and parties can see what I said, what other side said, and what tribunal is going to say. So that is basically the discussion. Though I deviated a bit from my original plan for today, but I had to tell you something which is very important, that in one arbitration which I just referred, now parties had devoted months and months, and the officers of the parties, then obviously it entails cost, because ultimately time is money. Now when that request and everything was got over, and we were before the tribunal, and we said now some documents In fact, in that case, no documents were produced by either side, and so there were lots of issues which were required to be gone into by the tribunal. Now, tribunal said that no, we will not decide this at this moment because we do not know what is relevant, what is not relevant. How can you, Mr. Singh, ask us to decide this issue at this stage because we are not aware of the relevance of the documents. Now, please appreciate by then parties had already exchanged their pleadings. So, the tribunal already had all the material before it to see what is relevant, what is not relevant. Now, if that tribunal says that we do not know what is relevant, what is not relevant, it surely means that tribunal had not gone through the files, not gone through the documents. And this is unfortunate. This is not how it's supposed to be. And if you have any foreign lawyer or a foreign arbitrator sitting in that tribunal, they'll simply laugh at it. And you as a chairman will be always criticized by both sides, by your co-arbitrators. So you should be very clear. In fact, what I do in my arbitration where I sit as sole arbitrator or presiding, ask both side lawyers in the very beginning of the case to present their case in half an hour or 45 minutes. Whatever they know about the case, what are they basically the case, what are their grievances. Now, I would have gone through whatever documents I would have received by then, and then I'll ask the lawyers to tell me what is their case. Obviously, I tell them, you will have opportunity to lead evidence, you will have further opportunities for discovery, you will have all the opportunities. I know construction arbitration or the joint venture commercial arbitration. So it's easy for me to understand the real issues. And you will be surprised to know that invariably in cases like this, uh, after hearing them for half an hour or 45 minutes, I get to know the real issue, and then I put across my understanding before the arbitrators, the lawyers, and I tell them, am I right in saying that this is really the real issue between the parties? They agree. In fact, on the basis of that, I am able to decide with the consent of the parties whether any cross-examination is needed in that case or not. Cross-examination is very costly procedure. It goes on for days and days and days and days. And obviously, I'll deal with cross-examination in some detail, maybe tomorrow or day after, whenever time comes. But you get the sense of the case, and the moment you get sense of the case, you go in complete control of the proceeding. You may have various applications being filed for various kind of reliefs during currency of the proceeding. So if you know the real issue, real dispute between the parties, the moment you see the application, you can say, hey, this is irrelevant or this is relevant. So this is very important. And same is the case with the lawyers. Please appreciate, lawyers are also supposed to know and go through every single submission which comes from the other side. Now, I said submission. So some of you may have some question coming to your mind. What do you mean by submission? See, written submissions is a phrase which is used interchangeably with pleadings. So these are interchangeably used with pleadings. And what are pleadings? Statement of claim, statement of defense. Then here we call it rejoinder, which is filed by the claimant. Other side, the respondent may file its counterclaim. I'll go into all of this in some detail, but just for completing this narration of this particular aspect I was telling you. So the submission is that, written submission is that. Now, Fine. Copy. Now, what I was talking about is, so it is equally important. Arbitration can be where written in an act before about SOC, SOD like Order 7 in CPC. Section 23 of Arbitration and Conciliation Act talks about SOC and SOD Shume. Now, let us come to see, it is very easy for lawyers to make allegations against the tribunal and say that tribunal is not taking note in charge, tribunal has not gone through the file, tribunal is not competent. But this is not how it is going to serve the purpose. The lawyers are equally the important stakeholder. And if you have good lawyer in an arbitration proceeding, it does hand holding of the all stakeholders. So as a lawyer also, you are supposed to go through all the pleadings, all the written submissions, all the documents, all witness statements, all applications. Moment you receive them, go through all the documents, in prepare for arbitration. What is case management? What is the case strategy? What is the case theory? I'll deal with that in a while when I'll deal with SOC in some detail. So question is, lawyers are also relevant stakeholder. They should also know what they are supposed to be doing. Now, therefore, read the file at the earliest, lawyers and arbitrators both. Another very important thing is, in big arbitrations, particularly in construction arbitrations, or in complex arbitrations, these arbitrations are very document heavy. So you will have thousands and thousands of documents. Now, as an RBC, that is why it is said that arbitrators should also be a good manager. He should know how to manage everything, how to manage the document. Someone may find this issue as not very not of relevance, saying what is there in documents. We will have documents, we will read it, we will apply it. So why even someone should talk about document and handling of document? Please appreciate when you will have tens and thousands of documents before you, running into volumes and volumes and volumes and volumes of documents. Then, and documents filed by both sides. Documents are filed sometimes. Some of the documents will be filed by both sides, same documents, or different documents are then filed. Now, unless you are aware that document management, and I'm saying this for the lawyers as well as for the arbitrators, unless you are aware of the requirement of document management, unless you have either seen others doing it, how they do it, or unless you have really worked very hard to have the mastery over it, it will be really unmanageable. And if you do not have control over documents, obviously you do not have control over the case. Because when you are filing documents, what are documents? Documents are evidence. And please appreciate, in international arbitration, or sorry about international, forget about international arbitration, even in domestic arbitration, arbitrations are largely decided on the basis of documents. because these are commercial transactions. Now, for commercial transactions, you cannot say these documents were voluminous, therefore I could not go through all of them. I am sorry. This is not how it is done. So mastery of documents, for that how we do in international arbitration generally, and I follow this practice even in Indian arbitration wherever I am in a position to impress the arbitrator and other side. I'll deal with that. There is a process called bundle. There is a process called core bundle. There is a process called hearing bundle. There are different processes, how documents are to be arranged, how documents are to be filed, how documents are to be tabularized. So all of this awareness is required on the part of the arbitrators and the lawyers, so that howsoever document heavy your arbitration is, you will be at ease with yourself. Otherwise, you will not be able to sleep. It will snatch away your sleep. Because the moment you think that I have thousands and thousands of documents filed by both sides, uh, you are in big problem. So therefore, management of document and proper management of document, efficient management of document makes your life easier. And please take this advice with seriousness. If you take this advice seriously, when you will be faced with those kind of situations, then probably you may remember me. Now, uh, arbitrator is also supposed to know all the best practices involved, best practices everywhere. As we talked about, you should know the different legal cultures, different legal systems. And in fact, as a chairman, I'll tell you, there is a famous saying that chairman of a tribunal, the presiding arbitrator, goes for the menu which his co-arbitrators select. So what is this? What is this I'm talking about? Every presiding arbitrator or chairman will try to take the co-arbitrators along, so that there is in good bonding amongst the arbitrators, good working culture, professional culture gets developed, and arbitrator being in good rapport with the presiding arbitrator, being in good rapport with the co-arbitrator, it makes his life easier while writing the award. Now, these were some of the aspects which we should keep in mind as an arbitrator. Now, another thing which we need to discuss is what happens now. We talked about arbitration agreement, we talked about selection of arbitrators, we talked about section 9 proceeding in between and challenges to arbitrators. Now we are at the stage where arbitrators are appointed, and now proceeding is going to start. So what happens then? What happens then is that arbitrators will will call for a preliminary meeting, and then arbitrator during the meeting will decide, and thereafter proceed is taken with all seriousness, and it is very, very important piece of paper. My internet connection is bit unstable, I think, so just check that. Okay, I hope I am audible to all. Okay, now, so arbitration agreement was written, arbitrator was appointed, arbitrators are in charge now, and now what has to happen? So first thing is you will have preliminary meeting. Uh, Obviously, in domestic arbitration, preliminary meeting, all parties are called for personal hearing. In international arbitration, also sometimes lawyers and parties are called. It is always a debate whether personal hearing is required for the first preliminary meeting. There are two schools of thought. One school of thought is that let arbitrator decide, and if need be, let arbitrator consult and propose the draft of the procedural order to all the parties, and after their feedback decide for itself what should be the procedure. And along with the procedural order number 1, procedural timetable we call it, is also prepared and issued. I would say to the extent possible, there should be personal hearing for this procedural order number 1 for issuing this and for this preliminary meeting. And if you ask me why, because I favor this school of thought that there should be personal hearing. Even in, I'm talking about international arbitration, domestic you must. There are one fundamental reason which applies all the across the board for domestic and international both is you get to meet personally all the arbitrators, you get to meet personally the other side lawyer, the parties. And it is very important for all of us to know that knowing your tribunal, knowing your arbitrators at the earliest is very important. As any good litigator will tell you that knowing the judge is very important. And in fact, I, in my office, always tell my juniors, whenever you are going for outstation matters, if you have not appeared before a particular judge, even if your matter is very late in the list, go and sit in the courtroom at 10:30 or 10, whenever court sits, and observe the judge. His approach, how he decides the cases. So every judge is different. And equally, every arbitrator is different. So knowing your arbitrator at the earliest helps you in strategizing your whole process. This is one of the part of advocacy that you should take with this aspect with all seriousness. That is my advice. Now, this is one of the fundamental regions. And secondly, you are in the first procedural order number 1 in the preliminary meeting. Basically, layout is prepared for the entire arbitration proceeding. And you will get to know what I mean by saying that layout is prepared and decided. And please appreciate, once procedural order number 1 has been issued, then that remains forever. Now, what is that we write in procedural order number 1? Procedural order number 1, what we write is time for submission of the statement of claim. Time for submission of a statement of defense. Time for submission of counterclaim if the other side, being the respondent, has any. Time for reply to the statement of defense to the counterclaim, whether any extension of time will be granted or not. If it will be granted, whether it will be subject to any cost. What will be the circumstances in which time will be extended or not extended. Procedural order number 1 also tells you how to write your SOC, how to write your SOD, statement of claim, statement of defense. Sometimes they will tell you it should run into how many pages. How should you structure your statement of claim? Not the content, but the structuring, the formatting. Sometimes tribunals suggest that as well. How should you annex documents? How should you, when you file your documents along with the statement of claim, you will be asked to refer them to as exhibits. So exhibit 1, exhibit 2. So what they will write in the procedural order. If claimant is filing a document, claimant should write C, which stands for claimant, C1. So document number 1 of the claimant. Whether you should write C1, C2 at the top of the page or at the bottom of the page. Now you may laugh at this. How is it really important? It is very important. Because claimant is filing document, respondent is filing document. If you do not write C for claimant and R for respondent, tomorrow you said exhibit number 100 or 150 or 1050. Now both sides have filed this. Now how you should use separators after every annexer. So what you do is you can Google and you will find separators are available in market in stationery shops. So tabs A 1, 2, 3, 4, 5, 6, 7, 8, 9. How should you put your documents? How should you put your statement of claim? So there they will say it should be put in the arch file. Here sometimes we call it box file, arch lever file. Now somebody may say, hey, what is this? This is not relevant. Very relevant. And you should do indexing so that 10, 20, 30 arch lever files are sent. At the spine of that arch lever, you should write this is claimant's statement of claim. Second volume is claimant's exhibit C1 to C80. Third arch file says this. Now imagine you have 80 arch files or 40 arch files. When I'll discuss about hearing, I'll tell you how these arch files are to be kept at the time of arguments. If you do not know how to put these arch files in the hearing room, you will simply go mad. One box file after another, one is lying here, one is lying there. So parties are advised, and in good hearing rooms, which unfortunately we do not have in India, good hearing, there will be a table where you can put your arch files, a spine facing towards you, all arch files kept in sequence. So the moment you need arch file 8 or 10 for which you have to prepare another index, you just take out that. Otherwise you put in front of you, you have to talk to the tribunal. Sometimes it falls here, sometimes it falls there. Looks insignificant, but in practice it is very, very relevant. That's why sometimes people say arbitration is an art of managing arbitration, how you manage the whole process. Now, in the procedural order number 1, so they will say that what should be the font size, what should be the size of the paper, A4 or A3, whatever. So invariably they will say A4. What should be the typeset, book antiquar or Times New Roman, and they will say the same typeset should be applied by both parties in every submission, written submission and every document. They will say so that volumes are lesser. It gives you psychological satisfaction and calm that I have less number of volumes to go through. Then what should be the indenting? What should be the margin? And most importantly, what should be the spacing? Not like what people have been doing so far in courts here. It should be 1.5, not 2. Font size should not be 14, 16, 18. It should be 10 to 12, depending on the requirement of the tribunal. So these are very, very important. Now, what we also talk about is in procedural order number 1, the language. Now, again, some of you may laugh at it, but imagine you have two parties coming from different nationalities, and lots of documents are in different language. How do you manage them then? Tribunal is not supposed to do translation for the parties. So that's why please appreciate in international arbitration, language is a very, very important thing. So if you have not agreed for the language in your arbitration agreement, then at least in procedural order number 1, invite tribunal's attention. When I'm talking about the procedural order number 1, you as a lawyer should not think that it is only for the tribunal for passing all the orders and going to all these aspects, because you may have a situation where tribunal may not be vigilant on this, or may not be cautious on this, or aware of this. You may have some situation inexperienced arbitrator. But if tomorrow you get as a lawyer other side writing everything, I have experienced it, other side writing something which could have been written with 1.5 spacing and proper structuring in say 80 pages, it was running into 300 pages. So ultimately it irritates me, it wastes my time. So therefore, both the lawyers and arbitrators should be equally responsible for proper drafting of procedural order number 1. Now, one thing which is very important, which happens in international arbitration, and which is happening in domestic arbitration also, wherever you have experienced lawyers and experienced arbitrators, we refer to as bundles. Now, what happens invariably in arbitration or court proceeding, you would have seen that parties file the documents, emails, letters, and everything as per their understanding. So, something of 2010 may be the first document, and thereafter, second document may be of 2009, fourth document may be of 2015. So, there is no system in filing the document, because sometimes parties file documents as per the facts they set out in their pleading. You cannot stop them from writing the way they want to write their SOC or SOD. But, and again, as I said, you may have a situation where Same documents, let us say contract document. Now, typical commercial contracts are few pages, but in the construction, engineering, infrastructure projects and those kind of cases, contractor, the contract documents itself runs into thousands of pages. Now, both sides are filing them. So again, it makes the whole process voluminous. And apart from that, you have two documents. Sometimes you refer to one, sometimes you refer to the another side, filed by another side. One side refers to this, another side refers to this. So you have marked in both, it creates problem for you. So when we talk about bundle, what we do is, we say claimant in consultation with the respondent will prepare a bundle after written submissions are over or witness statements are over. What common index, like whenever claimant has, if claimant has filed its document, claimant would have said exhibit C1 to C430. Respondent would have filed R1 to 230. Now prepare, so there are two indexes. So now tribunal will ask you to prepare one index after documents are exchanged, all pleadings are complete. One common index, one will be for the plate. So, and then you have sub indexes also for pleadings, documents and evidence. Evidence means evidence by affidavit or witness statement. We'll talk about this. So pleadings are in 1, 2, 3, 4 arch files in sequence: statement of claim, statement of defense, counterclaim, their reply. So 1, 2, 3 arch files made for that. All documents, for all documents there will be common indexing. How do you make the common indexing? All the documents will be put in sequential manner, in a chronology. So document, whether filed by claimant or respondent, if it is, whichever document is the first in point of time, should be the first document in that common index. It takes time. There is lot of inputs are required from the paralegal people, your court clerks, your colleagues in office. So what you do is put all the old documents first and then you move ahead. Now in the index, you will have column, whether one column is for claimant, another column is for respondent. If that document is of claimant, then write in that column claimant ka ye document hai. Or do you write that C, if it was C10, write C10. But on the left hand side, you are writing 1, 2, 3, 4, 5. Here you are writing, if it was C10, which becomes the first document in the index, write first document on the left hand side, right hand side C10. Thereafter comes document filed by respondent, it is R103. Second document R103. You should write also description of the document. What is this document? This document was a letter written by the site engineer to so and so. So that indexing helps everybody immensely. And this is one thing very, very important. So, and avoid all duplicacy, means any document filed by both sides will not be kept in that, means only one out of the two will be kept in the file. So what have you now? You have all documents in chronology, duplication gone, joint and common indexing has been done. So you know whole flow of the case as an arbitrator. As a lawyer, you know whole flow of the case. Ultimately, what is that arbitrators are supposed to do? Arbitrators are supposed to recreate the whole activity, how it would have happened when the contract was being executed or what transaction was happening. So this recreation of facts is the biggest challenge for any arbitrator, and this is what arbitrators can do with ease if he knows how to manage documents. Now, another thing which is being written in the procedural order number 1 is whether parties will have simultaneous during the at the time of cross examination, at the time of oral submissions. Now you may ask this question, what do you mean by simultaneous transcription? Simultaneous transcription is a facility. See, you all would have seen in courts and in offices stenographers. They take dictations in shorthand. But what happens? After dictation is given to them, then they go back to their room, and from their shorthand notebook, they type on the computer, and thereafter he takes out the printout. So, though he may be having very good speed in taking the dictation, as a result of which he can match with the speed of the speaker or the judge or the office superior, but that office superior cannot immediately have a look at this. What is that I have dictated? Till the time that stenographer goes and types it. So it is a duplicacy of the whole process. First he takes the shorthand note, then he types this, then he comes. However, simultaneous transcribers are very, very efficient and very, very efficient set of people. Very few. In India, we don't have any. So whenever I have arbitrations in India where I need simultaneous transcribers, we call them either from Dubai or from London or from Singapore. And they are very costly professionals. They charge you in lakhs on per day basis. And then you have to pay them for their airfare and all expenses, 5-star hotel and all of that. But it is worth paying the exercise. So what they do is every single word uttered by anybody in the hearing room, be the arbitrator, be the claimant's counsel, be the respondent counsel, be the witness, every single word uttered by anybody in the hearing room will get displayed simultaneously on everybody's laptop. The moment you enter into the room, you will find many laptops kept on the table. So everybody sitting in the room will be provided with one laptop by that transcriber. So what you see, every single word you utter, and you find this being appearing on your laptop. How they do it? They have a specialized shorthand typing machines, and they have a software which translates this automatically in English, and there will be always not less than 2 people, and one person will keep making changes, corrections if any. So simultaneous transcription, in fact, without naming, or in fact I can name, Michael Wong, in one of his writings, in the name of Michael Snyder, whose name I took yesterday, he wrote in very small piece of article. He shared his experience with one Indian arbitration, and he said that in India I faced very typical situation where questions are put by the lawyers, it is corrected by the arbitrators, thereafter answer is given by the witness, thereafter that answer is corrected by the arbitrator, and thereafter one person takes dictation, he types it in longhand. He said it is very frustrating. He says, don't go to India to have as an arbitrator until unless you have simultaneous transcription facility. You can imagine the importance of simultaneous transcription facility for good international arbitrators. So you can, where I had simultaneous transcribers from Dubai, and they did amazing job. So, and it saves everybody's money. The kind of cross-examination which you otherwise do in India in 10 days, you can do in 1 day or 2 days. So that saves a lot of time and a lot of money in terms, even if you talk about money. So why can't we do this? Thereafter, in the procedural order number 1, tribunal will say whether anybody wants to, if anybody wants to use PowerPoints, we are okay with this. So PowerPoint presentation. Now, what they also do is that if they say, will you have any witness who will be speaking in different language than the language of the arbitration? Yes, if that is the case, then you will have to have translator. I was doing one arbitration, ICC arbitration in London. There what had happened was, one of the witnesses was not speaking in English. In fact, one of my witnesses also had the problem. So we had 2 translators. One, my witness was speaking, was not fluent in English, though I may discuss on this particular aspect the technical regions to have translators while I'll be discussing the translation cross-examination. But here to discuss this, translators, so we had one person who could translate from that particular language to English, and this translator, another translator who had to translate the Hindi into English. And those people are again very experienced. They have experience of doing translation for court and arbitration proceedings. So they know how it works. Again, they charge you. In fact, they are also administered oath. The way you administer oath to the witness, you administer oath to that particular translator also, so that he does not translate something else than what has been said by the person whose statements are being translated. So again, that is important aspect. Now, oath. Now, under in Indian setup, under Oaths Act, arbitrators can also administer oath, and arbitrators administers oath. You can go to notary public, you can go to oath commissioner, they also administers oath. Now, but what happens is, in international arbitration, in some of the jurisdiction, oath taking exercise is very, very relevant. Otherwise, your award may get set aside. Like in Middle East, in fact, you will be carrying 2 books. One would be Bhagavad Gita, another would be Bible. Because people of 2 faiths were supposed to testify. So for oath taking, they'll be asked to, we were asked to carry the books. Though it was not used in a real sense, though they were administered oath, but they were not asked to touch the holy books. So that is another aspect. In fact, very popular in India these days is that arbitrators will write in the first procedural order that what kind of questions cannot be asked during cross examination. They may say you cannot ask questions on the content of a document, so on and so forth. In fact, Michael Wong, I would say he would be one of the pioneers in this field who came very early with don'ts for his procedural orders. So he will annex one complete set of don'ts along with the procedural order, where you will say you will not ask these category of questions. No question on documents, no question on motive relating to a particular act and omissions and all of that. In India, it is very popular for our honorable judges who after retirement sit as arbitrator to again follow some of this in some of the arbitrations, which is again a very, very important aspect to be kept in mind. It is 6:54 and I lost track of time because I thought these are very procedural requirements which we all should keep in mind. Sumit Kansal says with procedural order number is so typical, why not uniform globally? Sumit, then arbitration will not remain arbitration. Every case will have its own nature, requirement. Some of the things may be typical, like the typeset, the font, even elderly people say no, sorry. Elderly arbitrator says no, I don't want 1.5 spacing. I have difficulty in reading them. So it depends on case to case. So let us have some questions. Questions, Weber. I had said that we can have questions today. Of contempt in the process of proceeding of arbitration. It was a debatable issue because there is a provision in Arbitration and Conciliation Act which talks about contempt, but now law is settled that there is no power as such with the arbitrators to issue contempt. Somebody had asked a question on section 23. Can you repeat that question again? I couldn't see that. Can I have questions here? Lots of the questions, I can see this. Good evening, good evening, good evening, good evening, good evening. Good evening. Srishti Girdhar says, sir, sufficient opportunity is very wide term. Does any judgment tries to define it? There are lots of judgments in India and all over the world, which says, because what happens is, invariably, while challenging the award, people raise this issue, I was not given sufficient opportunity. And you will find number of cases dealing with this when something amounts to sufficient opportunity and not. This is like public policy. Can you define public policy? When a public policy, so it's again very, very, as you rightly said, it is a very open term. So therefore you cannot have any objective answer to it, but there are number of judgments. Yes. Sir, where written in advocacy? Oh, where can we challenge the arbitrator, whether before the tribunal or the court? I have said it twice. If it is ad hoc arbitration, you have to make challenges to the appointment before the tribunal. If it is an institutional arbitration, you have to go by the institutional rules, and institutional rules generally says that it will be decided by the court of the tribunal, not by the arbitrators. What should be contractor do when the said project is already in an arbitration and the proceeding is in place? Now the employer ask the contractor to complete certain work pending, which is already part of the arbitration. What is your suggestion in this case? Is it appropriate to seek interim injunction? See, interim, somebody has asked a question that disputes relating to the project is already in arbitration, and contract employer is still insisting that work should be done. See, first of all, there are certain invariably in the standard forms of contract, it says that notwithstanding the fact that parties are in arbitration, you have to continue with the work. If you have any similar clause in your arbitration agreement, then in that case you have to work, provided you have not terminated the contract or other side had not terminated the contract, or you have not suspended the contract or other side has not suspended. It depends on lots of factual issues or other issues. You may contact me if you want. Under section of arbitration, if contract becomes void on ground of public policy and the party does not want to appoint an arbitrator, under section 11 of the act, is the High Court still allowed to appoint? See, whether contract has, somebody has asked it whether a contract is void. So whether arbitrator, while filing the section 11 application, whether voidability can be seen and whether it can go to arbitration. Question is, if contract is void, one party goes for arbitration, whether court will refer the parties to arbitration? Answer is yes. Voidability is one thing which cannot be decided by the court while entertaining section 11 application. There are limited grounds on which you can do this. Only thing what court while appointing arbitrator has to see is whether there is an arbitration agreement or not. What next? Somebody says, like in section 23(4), the time limit for pleading is 6 months. But what if party agrees to extend it? Will it not be against the statutory provisions? See, this is a very interesting question. You need to have clarity on this. It will require some clarity from the court. It says 6 months time for completion of pleading. Now, this 6 months cannot be mandatory in all the cases, irrespective of the manner in which this particular provision is caused. Because you may have situation, like talk about this situation of COVID-19 outbreak. What happens to that situation? Can you say that no statement of claim, no statement of defense? Can't be. Can we challenge the award on the ground of violation of principle of natural justice? Nikhil Sharma. This is the most important ground on which you can challenge. Most important ground on the basis of principle of natural justice. What? Any other question? Any other question? If you have any. So I don't see any other question. So if that is the case, then we'll wrap up to today's talk and we'll meet tomorrow then. Rahul? I can't hear you, Rahul.
Yes, sir, we can do it, sir. We can wrap up the session as for now. We are done with the session as the time is up.
Okay. So we'll meet tomorrow then. Fine.
Thank you, sir. Thank you so much, everyone. We'll join tomorrow at the same time, 5:30 p.m. with Ratan, sir. Thank you so much.
Thank you. Thank you, everybody. Thank you very much.